The first case of the morning is State versus Weideman. You'll have 15 minutes to the argument. You're the only person here, so of course you wouldn't be rebutting the appellee anyway, so you can just come up and make your 15-minute presentation.
Thank you, Your Honor.
You're welcome. When you're doing that, please remember that presentation is being recorded, both visually and audio, so please stay behind the podium so the video picks you up, and please speak loud enough so we can hear you during that time. Should not use the name of any child, minor, or victim. Don't really have that in this case, but if you do, use an initial or some other designation rather than the name of the person.
Yes, Your Honor.
With that, we read your brief and are ready to proceed whenever you are.
Thank you, Your Honor. Good morning, may it please support. My name is Megan Philbin. I represent the appellee of the state of Ohio in this appeal. This appeal arose after a jury trial was held in the Medina Municipal Court, wherein Mr. Weideman was found guilty of operating a vehicle under the influence of alcohol under ORC 4511-19A1A. Also, he was found guilty of operating a vehicle while under the influence of alcohol with a refusal and a prior conviction within 20 years under ORC 4511-1982, and then also 2 additional minor misdemeanor offenses as well. So the appellant raises 3 assignments of error. I'm just going to go through each of those assignments of error. The first assignment of error was whether Mr. Weideman's convictions were based upon insufficient evidence, and specifically Mr. Weideman contends that the state did not present sufficient evidence that he was operating a vehicle while under the influence of alcohol. So
how can we assess that with the missing parts of the transcript?
well, you are correct. That's also part of the appellee's argument here, is that the entirety of the record was not transcribed because I believe the file was corrupt, and the state's position that it's on the appellant to transcribe the record. I do believe there are other ways other than just pure transcription of the audio that they could have supplemented the record here, and they had not done that in this case. So it's our
I've not had a
position.
chance to see the record yet, so is it a bunch of inaudibles that we're talking about, or are there large parts of the case that just aren't there? What are we talking about?
Yes, so large parts of the case are not there. I believe the entirety of direct examination of the state's witnesses is there, but any time that it was cross-examination, it is not there, and any of the defendant's case is not there as well. So those are the very large pieces that are missing. So it's the state's position that we're to presume regularity of the record when it is absent, and it's on the appellant to have transcribed that.
So counsel, I apologize, I have coughing spurts here, so I'll try to get through this. So you're saying that the transcript does include, excuse me, your transcript does include the state's whole case?
Yes, so the direct examination, but not the cross-examination of the state's witnesses.
Is that true? Isn't there some cross-examination missing from an officer? And
Yes,
the
I
state's
believe the entirety of cross-examination is missing from the officer.
from the
and-
officer for the state's case, so
Yes.
so we don't even have that whole state's case.
That's correct, so that is the part that is missing, and also there is another third-party witness that the state did call, Mr. Rodriguez. His cross-examination is also not in the record as well.
Okay.
Just as a side note, the municipal court has fixed that issue that was happening during that. It was an issue of their audio system, specifically with the defense counsel's microphone on that side, so.
And defense counsel made no efforts through the appellate rule to try to supplement or correct the record at this point in time.
Yes, that is correct, Your Honor. So the state did have 2 witnesses testify. Like I already identified, these 2 witnesses, their testimony was transcribed, but not their cross-examination. So the state had Officer Denton from Montville Police Department testify, and he had testified that he came upon a motorcycle crash, and he saw 2 men standing off the side of the road. One was very obviously involved in the motorcycle crash, the other was not involved, and he could tell that by Mr. Weideman. He was covered in blood, he had a very apparent broken arm, he had urinated himself, he was bleeding, and the other individual was not wearing shoes, he was in casual clothes, and the crash happened in front of that third party, Mr. Rodriguez's home. So also, when Officer Denton had arrived, Mr. Weideman, the individual who was injured, attempted to walk away, and he was again urinating when the officer arrived. The officer had believed that Mr. Weideman was the operator given his physical injuries, the condition of the motorcycle was totaled, and Mr. Weideman's answers to some of his questions. So when the officer asked Mr. Weideman how the accident had happened, Mr. Weideman responded that he was on the rubber, then he was not. which was interpreted to mean that he was on tires and then he was not. And then also, the officer asked him, where were you coming from, where were you going to? Mr. Weideman gave a location for each of those and never identified that anybody else was involved in the incident. There was never another driver or operator identified at the scene or during the trial. As to Mr. Weideman's appearance being under the influence of alcohol, the officer testified that Mr. Weideman had slurred speech, he had bloodshot glossy eyes, he had a strong odor of alcoholic beverage coming from him, and that was in addition to everything the officer already saw. But the officer then asked, have you been consuming alcohol? And Mr. Weideman's response was that he had one beer, and then he turned to the officer's body camera and asked, did you get that on the body camera? So that was also submitted into the record, was the body camera of the officer. The officer then asked Mr. Weideman to submit to a urine test they believed on the way to the hospital, and very explicitly was told no, that he would not be providing any samples to the state. He said hell no amongst other things that I'm not going to say on the record, but they are on the body camera. Then the state did call Jordan Rodriguez to the stand, and he had testified he had heard this crash happen in front of his home. He saw a large spark outside of his kitchen window. He went outside to check on what that was. Admittedly, there was a time lapse that that Mr. Rodriguez stated that he waited a few minutes before he came outside, but then he saw Mr. Weideman covered in blood and very disoriented, but Mr. Rodriguez testified that Mr. Weideman repeatedly asked him, do not call the police, please do not call the police. So based upon both the officer and Mr. Rodriguez's testimony, the jury properly found that he was guilty of operating a vehicle under the influence of alcohol. There was also evidence that the state had submitted of Mr. Weideman's prior conviction and the refusal, and the jury properly found that he was guilty of that offense as well. So moving on to assignment of error number 2, the issue of the transcript kind of bleeds into this issue as well, because the second issue is whether Mr. Weideman's convictions were against the manifest weight of evidence. Clearly, we don't have everything that was in the record, so that's foremost the argument there from the state is that it was on Mr. Weideman to transcribe the record and provide it to the court here, and the state's argument is that we're to presume regularity in the record if it's not provided by the appellant in the case. But it's the state's position that we have met our burden of persuasion in this case. There was substantial evidence that Mr. Weideman was guilty by way of the testimony of the officer and his third-party witness, that he was operating the motorcycle, and that he was impaired by alcohol. Here, the jury had the opportunity to perceive the witnesses, the state's witnesses, and also I believe there was a defense witness as well, and determine the credibility of these witnesses and weigh the evidence, and they did not lose their way. So I'm asking that those assignments of error should be denied. Getting into the final assignment of error, we have whether it was an error of the trial court to deny Mr. Weideman's request for a jury instruction on reckless operation and failure to control. So the trial court had denied this request, and their basis was because reckless operation and failure to control are not lesser included offenses of operating a vehicle under the influence of alcohol. There is a case out of the Ohio Supreme Court that's established a test to determine whether an offense would be a lesser included offense, and that's State versus Dean. So the three factors in determining whether it's a lesser included offense is one, if the offense carries a lesser penalty than the other. So going through reckless op and failure to control, yes, those are lesser offenses. They're both minor misdemeanor offenses. OVI is misdemeanor of the first degree or unclassified. So they pass the first prong of that test, but when we get to the second prong of the test, this is where it fails. The greater offense cannot ever be committed without the lesser offense. Here, you don't necessarily have to commit reckless operation or failure to control to get OVI. There are plenty of OVIs that are not based upon reckless operation or failure to control. So the elements of each of those offenses do not overlap. So OVI does not rely upon the reckless operation or failure to control to be committed in order for us to get OVI. So the state's position, this is where it fails. And the trial court did not get it wrong in determining that those are not lesser included offenses of OVI. So
do you think that's purely a legal question, has nothing to do, usually you have to have some facts that match up for the judge to get to give a jury instruction. Do you think this is a purely legal question, that we don't need a transcript?
I believe, yes, that is a purely a legal question in this particular case. To be honest, I think from what information we do have, I think even in the, well, I'm not certain what if the judge's, response to the, request for jury instructions, I'm not certain, because at any time, basically, in the record that defense counsel was speaking, that part is just completely missing from the record. So, it may rely upon that as well, Your Honor. So, I would ask that, this assignment of ARB be tonight as well, and I would ask that the decision of the trial court be affirmed in this case. Thank you.
Thank you. And thank you for your presentation this morning on behalf of the court. The court will take the matter under advisement, will issue a decision in due course. When that decision is released, it will be mailed to you by the clerk of court and also be available on the Ohio Supreme Court website.